Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today we are continuing on with the changes that the Georgia Association of Realtors, or GAR, has made to the contract package for 2021. Please see the links below in the description for the other video tips I've done on these changes, as well as a link to a free virtual CE class on the 2021 GAR changes that is offered through the Georgia Real Estate Academy and hosted by Maximum One Greater Atlanta Realtors, actually hosted by all the Maximum One companies. You'll see the links below. Ongoing classes, live, interactive, virtual classes, free through January 2021. So please see the link below and watch all the other videos. So today we are continuing on and we are going to talk about the changes that the GAR Forms Committee has made to the sale or lease contingency exhibit. Now, not a lot of, well, actually, let me get into it. I think you listing agents, I think you are really going to enjoy the changes that GAR has made this year to that form. So, let's just dive in. There's a lot of changes that GAR made mid-year 2020. They separated out the kickout clause and just explained it a little bit, and then went on to, in the form, in the exhibit, what specific contingencies would be kicked out in a particular transaction that the buyer and the seller negotiate. So they did leave that in there. That change was actually made in May of 2020. That has stayed in there. And then they've made some additional changes for clarification and for, like I said, you listing agents. I think this is going to help put your sellers' minds at ease a little bit when looking to accept a contract contingent upon a buyer having to sell their current home. So let's dive in. Again, this is GAR, Georgia Association of Realtors, Form 601, Sale or Lease of Buyer's Property Contingency. Now, first thing, it has the offer date, it's an exhibit, and it's an offer for buyer's new property. So the situation is buyer currently lives in property A. They're making, and they want to buy property B. They're making their transaction to purchase property B contingent upon the successful sale or lease of their existing property A. So that's the theory behind everything that's going on. So it starts off like normal. It's an exhibit with an offer date, making an offer on the new property B. Now, it starts off, no change here. It says the buyer warrants that they own their current property A is, and this is the address. Then number 2, at the time of the buyer making the offer for new house B, this has been changed for clarification. You've got options A, B, and C. Option A, my house, buyer's house, is currently listed with, and you list the broker's name that the buyer's house that they live in now, house A, is currently listed with. Or B, buyer's current house is currently under contract with a buyer, and the buyer of the current house is represented by, you put the buyer's broker with the closing date of, and you put the existing closing date for the pending contract. And C is other. So first option, buyer, I'm just going to put myself as the position of the buyer. I'm the buyer. I want to buy new house B. I have to sell my current house A. Either I have my current house listed, but I'm not under contract yet. If so, I have the broker's name whom I have it listed with. B, I have it listed and I'm under contract. I list the broker representing the buyer of my current home and the estimated closing date, or C, other. So that's spelled out for clarification. That's item number 2. Item number 3, this agreement, meaning the agreement for me as the buyer to buy new house B, is contingent upon the following happening on or before, and I put in a date. So you have to have a date. Don't leave that blank. Either So either I have to sell my current home, my purchase of new home B is contingent upon me either selling my current home A or leasing my current home A. So the first part says, this is what I think you listing agents are going to like. Buyer, so this agreement is contingent upon the occurrence occurring on or before, fill in the date. And then you have to select either buyer closing on the sale of other property. Unless the other property is under a binding purchase and sale contract at the time of the offer, the buyer shall keep that other property listing for sale with a real estate broker at a sales price of not more than X amount of dollars until it is either sold and closed or the contingency period expires. And then option B is buyer entering into a lease on the property. Unless the other property is under a binding lease at the time of offer, buyer shall keep the other property listed for lease with a real estate broker for a lease term of not less than X number of months, nor more than Y number of months, and a monthly rental of not more than X amount of dollars until it is leased. So in other words, you agents, as you guys are negotiating through this sale or lease contingency, you get to negotiate. You listing agents, you get to negotiate. Number one, the buyer, in my example, me, I have to keep my current house listed with a broker. I can't put it up for sale by owner. And I have to have it at a price. There's a cap on the amount of list price that I have to list it for in order to enter into this contingency to buy the new home. So lots of specific, and same thing with the lease, lots of specific requirements for the buyer to actually act in earnest to sell or lease my current property. That terminology is brand new, and I think sellers are going to feel much more comfortable with that information. All right, number 4. In the event that the contingency period ends without either contingency being met, so in other words, that date that we filled in, that it must occur on or before whatever date, if that time frame comes and goes and I have not sold my house or leased my house, then the contract for new house B terminates. So there is an automatic termination after the contingency date if the buyer does not meet that contingency to sell or lease the house. That's been in there, you guys. That is not new. Prior to the seller giving buyer notice that the seller is exercising the kickout clause, which is explained below, the contingency or contingencies referenced above may be waived by the buyer upon notice to the seller. In other words, you have a buyer that financially, I've got to get rid of this mortgage payment on my current home in order to go through with the contract of my new home. You have another buyer that financially, I can afford to go through and close on the new home. I just really don't want 2 mortgage payments. If that type of buyer is who you are working with, then the buyer can always just waive this sale or lease contingency in order to go through with the contract for home B. Again, that has always been in there. Number 5. Now, let's say that I'm the buyer. I have my current house A, buying new house B. Current house A is under contract, but unfortunately that contract falls through. Let's see what happens with this contingency to buy home B. So brand new in number 5, paragraph 5, it states, in the event that the existing pending contract is terminated for any reason whatsoever, the buyer shall immediately provide notice of the same to the seller. Then the buyer shall have the right, but not the obligation, to either terminate the agreement on the new house at the same time of the notice, in which case the buyer will get all earnest money back. If the buyer, me in my example, if the buyer does not terminate the agreement when giving the notice that the contract I had fell through, then the seller shall have the right but not the obligation to request that the buyer sends an amendment signed by the buyer to remove all contingencies and all due diligence periods from the agreement to buy the new home. If the seller does not exercise that right within 3 days from the buyer's notice that the existing pending contract has terminated, then the seller's right to request that amendment on that basis shall be waived. In the event the buyer does not deliver the amendment within the 3 days of the seller requesting to remove all the contingencies, then the seller shall have the right, but not the obligation, to terminate this agreement for the new home. And again, buyer will get back all their earnest money. If the seller doesn't terminate the agreement within that additional 3 days, then the seller's right to terminate on this basis shall be waived. So you guys, you need to read that paragraph thoroughly. Keep track of your time frames. Make sure you send notice. Notice, again, as we've discussed in a myriad of videos, is not agent-to-agent email. It must be on a notice form signed by the buyer and signed by the seller. So reread that. Keep track of your time frames. All right. Then it goes on, number 6, kickout clause explained. Again, this was a change that the GAR Forms Committee made in mid-year changes of 2020, and they've kept that in there for 2021. It just basically describes what the kickout clause is. A kickout clause describes a situation when the seller of a property that is under contract continues. So now this is from the seller's perspective. The seller of the new home gets to continue to market that home for sale to other buyers because the buyer's purchase is contingent on the sale or lease of other property owned by the buyer. If another buyer makes an offer to purchase the seller's home that the seller wants to accept, the seller gives notice, again, not agent-to-agent email, but on the notice form signed by the seller, gives notice of the other offer to the first buyer, who must then submit an amendment to remove certain contingencies and possibly the due diligence period from the agreement. And in some cases, if it gets negotiated, pay additional earnest money to the seller. If the first buyer does not do these things within the pre-agreed time frame, the seller can then kick out the first buyer, terminate the contract, and go through with the contract with buyer number 2. If the buyer does meet the pre-agreed requirements of the kickout clause, which is explained and negotiated below, then the original contract remains in force subject to the terms of the amendment signed by both parties. Again, now, switching gears, you listing agents, if you have a kickout with buyer number 1, you get an offer from buyer number 2. Do not exercise the kickout before fully negotiating offer with buyer number 2 using a backup contingency exhibit and then exercise the kickout. Because if you don't negotiate offer from buyer number 2, you kick out buyer number 1 and buyer number 1 terminates, seller never gets to terms with buyer number 2, you're back at square one. So again, I've covered that in a number of videos, but just as a reminder here. Okay, so that's the kickout clause explained. Then paragraph 7 goes on for the buyer and the seller to negotiate what contingencies actually get kicked out if the seller gets another offer that they want to accept and goes back to buyer number 1. So there's either option 1 or option 2, and then there's sub options under there. So let's start with option 2. Option 2 states there is no kickout clause. That is by far the best deal for a buyer. That means the buyer goes under contract with the seller. Buyer has to sell or lease my current home, but the seller cannot kick me out. The seller just has to wait until that time frame, and either I sell my home or I don't. Definitely better for a buyer, not the best for the seller. Option 1 with the kickout is the better option for a seller. Option 1 says this agreement is subject to a kickout. And what you have is, in the event the seller receives a bona fide offer to purchase the property that the seller would like to accept, then the seller shall give notice, again, not agent-to-agent email, but the seller actually signing the notice form of the offer to the buyer. The buyer shall then have X number of hours after the receipt of notice to deposit with the holder additional earnest money of X amount of dollars, and again, that can be negotiated to $0, and deliver to seller an amendment to the agreement signed by the buyer in which the buyer agrees to remove the contingencies and or due diligence provisions that are checked below. So you have some options below. If option 1 is selected, but neither A nor B is filled out, then A is the default option. So if there is a kickout, the parties can negotiate. If the seller kicks out the buyer, wants to kick out the buyer, and the buyer wants to stay in it, then all contingencies and due diligence are removed. In other words, seller exercises a kickout, buyer says, nope, I want this house. At that point, there are no more buyer contingencies. The buyer must go to closing or the buyer will default on the contract. That's option A, and that is the default option if nothing in B is filled out. Or you can negotiate B. The following contingencies and or due diligence period checked below get kicked out. They're no longer part of the agreement. So you can negotiate sale or lease of properties contingency. So in other words, I'm going to keep, as the buyer now, buyer A, I'm going to keep all my other contractual contingencies intact. But if I get kicked out and want to stay in contract for the new home, I'm not making it contingent on me selling my current home. Or you can kick out the due diligence period. That's no longer a contingency in the contract. Or you can kick out the right to request repairs. Please see the video I've done previously on the difference between a due diligence period and the right to request repairs. Those are two completely contractual issues with different forms. They are not the same thing. Or you can remove any financing contingency. You can remove any appraisal contingency, any specific special stipulation or other. So again, mark through those, and the buyer and the seller, when going under contract, can negotiate what would get kicked out if the buyer A wants to stay in contract for the new home. Then it goes on about the time frames for the buyer to deliver the amendment if the buyer is going to stay in contract or is going to terminate because they can't remove the contingency, so forth and so on. None of that has been changed, but there are time frames in that, so please read that. And then GAR for 2021 has added paragraph 8 that does include a new section for additional special stipulations that have to do specifically with the sale or lease contingency. What do you think? Very interesting, very changes. Definitely a lot of changes for clarification between the buyer and the seller regarding the kickout. What happens? What gets kicked out? A little more assurance for sellers to give them a little more information from the buyer, what steps the buyer is actually taking in good faith, in earnest, to sell their current home in order to be able to buy the seller's home and buy that new home. So, love to hear your comments below. I'm curious what you think. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.